Good afternoon, everybody. I'm Gillian Sadlier, Vice Chair of the Ulster Society, and you're very welcome to the latest in our series of webinars with our legal partner A&L Goodbody. Feedback from members for this series has been really positive, and we're thankful to A&L Goodbody for their time and expertise. And it's great to squeeze in just one more webinar before the summer break. So for anyone who wants to catch up on our previous webinars in the series with A&L Goodbody, you can do so on our website, charteredaccountants.ie/Ulster. For today's webinar, we have Sam Corbett and Chris Coulter focusing on winding up petitions. The return of winding up petitions in Northern Ireland after being restrained for the last 3 years is expected to have an impact on local corporates and those who advise them. So today, Sam and Chris are going to cover the market context and potential catalysts, the industries which will most likely be impacted, some lessons learned from England where restrictions were lifted last year, and some practical hints and tips on how to deal with winding up petitions and their impact. Sam is a partner in A&L Goodbody's restructuring and insolvency team in Belfast. He specialises in all aspects of business recovery and insolvency related matters and has extensive experience in acting for local and national banks, financial institutions, funds, creditors and insolvency practitioners. Chris is a solicitor in A&L Goodbody's restructuring and insolvency team also in Belfast. He specialises in all aspects of contentious and non-contentious insolvency and turnaround matters. Chris has also conducted advisory and litigious work related to trusts, fraud, financial services and financial regulation. Please feel free to put your questions for Sam and Chris into the Q&A box at the bottom of your screen. Q&A is now open, so go ahead and type them in if you would like to. I ask that you keep your questions general in nature. Sam and Chris won't be able to answer specific legal queries during the webinar, but they will provide their contact details should you wish to contact them to discuss more directly. We have a lot to get through, so let's get started. I'll just hand over to Sam and Chris. Thank you.
Thank you, Gillian, for the introduction, and good afternoon, everyone. As you can all see from this opening slide, the topic of this afternoon's webinar is entitled The Return of Winding Up Petitions, which, as Gillian said, have been restricted within the Northern Ireland market since April 2020. And look, the genesis of this presentation was really twofold. Firstly, we had a change within the market, which was the change in restrictions in Northern Ireland, resulting in the unfreezing of those petitions for the first time in 3 years. And secondly, we had a number of members of the Ulster Society asking us for an update on what the current position is before the courts, and for a bit of a refresher, given that all of us and our clients could now be confronted for a winding up petition for the first time in 3 years. The restrictions on winding up petitions first were first introduced in Northern Ireland back in March 2020. And few, if anybody, would have predicted that the restrictions would have remained in place for 3 years. But now, as winding up petitions return, they return to a very different market than the last time we experienced them. So in terms of the structure of this webinar, what we're firstly going to do is to try to set the scene and tell you a bit about the market context within which winding up petitions are returning. We'll then give you a short overview of what the winding up process now looks like. But what we really want to do is to bring some added value and insight to members by providing you with some practical hints and tips around winding up petitions and what they expect. I suppose things you don't know that you didn't know, or to put it another way, things you might have known 3 years ago, but they just haven't been at the forefront of your mind in recent times. You'll also hopefully have noted in the slide the rising bubbles, and this isn't a nod to West Ham's victory in Europe last week, but rather to keep things interesting, which is always really difficult with a legal presentation. We're going to try and draw an analogy throughout this webinar between the market and a bubble. And there are really two elements here. Firstly, there are the market conditions, which can place strain in the bubble and can cause it to stretch and expand, sometimes to breaking point. And secondly, there are potential darts, which act like catalysts within the market and act as a threat to the bubble. And the catalyst that we want to focus on today being the return of winding up petitions. But firstly, let's start with some market context. So in terms of setting the scene for the return of winding up petitions, there are really many pressure points currently within our market, and they're placing pressures on corporates and causing them, like the bubble on your screen, to expand and stretch. Firstly, we have higher interest rates than the last time we experienced petitions. The last time we had petitions were around Interest rates were 0.1%, now they're at 4.5%. Secondly, we have higher inflation, 8.9% up from 0.7%. And whilst this is down from the 10% we saw earlier in the year, it is at a stubbornly high rate, and in some sectors is particularly higher than the 8.9% average. Then we have what we're going to focus on today, the lifting of restrictions and creditors in Northern Ireland. Those restrictions were lifted in England over a year ago, and if the lessons from England are anything to go by, there is a significant threat to the bubble, and we'll touch on those statistics later. And I suppose if those three factors were not choppy enough, what we're now seeing within our market is government sympathy waning. That's evident in the attitude of the government to public funding and to their recovery of COVID loans and bounce back loans. In terms of other market factors, whilst there is and does remain, thankfully, some liquidity within the market, in other and certain sectors, some of the liquidity in the market spent, and in many cases it's due. Further, not only have living costs increased since the last time we experienced winding up petitions, but within the space of those 3 years, we've pretty much moved from relatively low living costs to a cost of living crisis. And finally, as you see that bubble continue to expand on your screen, the market conditions aren't helped by continual instability in the market, whether that be locally here from Brexit or the protocol, or at a macro level with ongoing war in Ukraine, or failing banks, Credit Suisse and Silicon Valley being two recent examples. So in terms of trying to set the scene for you, the market conditions within which winding up petitions have returned to Northern Ireland are markedly different to the conditions that existed when we last had to deal with them back in early 2020. So that's a very quick overview in terms of a scene setter of what the current market landscape looks like. But as I mentioned, there are a number of catalysts, or darts as we have displayed them here on the screen, which could have a real and huge impact in the market. And any one of them at any stage could cause a bubble to burst. The first one is what we have termed changing attitudes. Over the course of the last 6 months, we, as I'm sure many of you have sensed within the market, a real move in attitudes. A move in an attitude of support, which we've all experienced over the last 3 years, to one of self-interest. This is evident within the government and the policy that's emanating from them, but I think it's equally evident within other key drivers in our market. We can see it now with HMRC and time to pay arrangements, and we can also see it with landlords and the attitude that they're beginning to take to tenants and rent arrears within the market. The second dart on the screen is refinancing. When we had petitions on the pitch back in 2020, refinancing was comparatively easier. Refinancing now, though, 3 years on, has become much more difficult to obtain. It's at a much higher cost, with the rates up to 4.5%. But not only that, I think you'll all have experienced for yourselves and for your clients the tightening within lending conditions that there's also been in this period. And that is a key difference from the last time we were dealing with petitions. Thirdly, we shouldn't ever forget about existential threats, whether that be inflation, crisis, war, failing banks. Some things just come out of left field in this market. And we've seen that many times in recent years. Whether in pre-pandemic it was the impact that Carillion had within the construction sector, or whether going back to the recession of 08-09 that Quinn had within the manufacturing sector. Some things just come out of left field and pop the bubble. And finally, we have the change in law, the return of winding up petitions, which we're here to talk about, and that really could be the dart that hits for some. Any one of these darts could cause the bubble to burst. But before all four coalescing together, it's extremely difficult for any company to navigate a path that avoids all of those darts. And with that in mind, it's worthwhile considering, well, what sectors and industries might be experiencing pressure points the most, and what sectors and industries might have most to fear from the return of winding up petitions.
And these pressure points have been felt throughout the market, but particularly in the 7 industries highlighted on the screen. Rather than go through each of these in turn, we're just going to focus on 3 or 4, starting with the construction industry, because it was really the first industry to experiencing that shock from rising prices. It's obvious to say, but in this industry, there was inflation hit, coupled with a fall in demand and skyrocketing interest rates, which put considerable pressure on already very tight margins. And interestingly, the construction sector threw off one of those existential insolvencies that Sam mentioned with the collapse of Carillion. Nobody predicted this in the market, but it had a huge domino effect on other operators in the industry. Much like construction insolvencies can have huge ramifications for the economy as a whole. If we look at the 100 largest construction insolvencies in the UK in 2022, they accounted for lost revenue of 3.3 billion, which is a considerable sum. And part of the problem in the construction industry is that it's dominated by fixed price contracts. So suppliers struggle to pass on these rising costs to the consumers. And that's a similar problem that's being faced in the care sector. And unfortunately, nursing homes, care providers, and childcare providers are coming under increased financial strain due to the rising costs in the context of their fixed price contracts. So if you have any clients that operate in this sector, it's worth keeping close to them at this time. It won't come as a surprise to any of you that the food production and the hospitality sector are also under considerable strain. And this is caused by inflation, as well as rising food costs caused by Brexit and the war in Ukraine. We've all noticed this in our personal lives. You just need to go into the shop and you see every single time the prices have gone up and there are fewer yellow stickers. But to really understand the strain this industry is under, we need to take a closer look at the rates of inflation. As Sam mentioned, the UK average is around 8.9%. But in the food production industry, for food and non-alcoholic drinks, it's at 19%. The industry's staple goods that are most affected. For example, olive oil is up 46%, whilst flour is up 30%. And you can compare this to the rate of inflation for non-essential goods, which, sticking with the theme of this presentation, we've picked bubblegum. It's only gone up by 18%, so below the average. Finally, another industry that nobody will be surprised to be experiencing difficulties is the retail sector. You just need to walk down the high street in most towns or cities to realise that this is an industry under strain. And this is largely driven by the change in consumer habits and the move to online shopping, which was accelerated by the pandemic and lockdown measures. And interestingly, this is also having an impact on the way these insolvencies are being managed. Historically, if a major retailer was sold out of administration, the staff and stores would all be saved. But this is no longer the case. If we look at Next's acquisition of Joules, for example, 20% of the staff and stores were lost. Likewise, in the administration of Topshop and Debenhams, whilst the brands were saved and moved online, the staff and the stores were left behind. So this is deepening the impact that these insolvencies have on those most affected in the industry. And if we take these 7 sectors as a whole, they account for roughly half of the UK's total insolvency activity. And when talking about potential catalysts in the market and a potential oncoming recession, which I feel like everybody has doing for the past 3 years, it's natural to begin to make comparisons to 08-09 and also to begin to take a closer look at the insolvency statistics, which for England and Wales at least do paint a stark picture. In 2022, England and Wales saw 31,606 corporate insolvencies. So even though creditors remained restricted during Q1, because remember, England didn't lift their restrictions on winding up petitions until April last year, 2022 still saw the second highest ever annual insolvencies in England, with only 09 having marginally more. That's nearly a 20,000 increase on the number of insolvencies in 2020, which sat at 12,557. And overall, that's a rate of increase of over 150%. Turning to NI then, where the creditors have remained restricted until April this year, the statistics tell a different story. We had 270 insolvencies last year, which is an increase of 82% on the 2020 levels. And whilst an 80% jump still sounds like quite a lot, it's important to remember that that's an 80% jump on the rock bottom level of 148 in 2020. Yes, Northern Ireland's always going to have fewer insolvencies than England, being a much smaller jurisdiction. But these statistics clearly show us that our insolvency market is lagging behind England's. And we can tell this from the fact that our rate of increase is just over half that of England's. And as well as this, 2022 was far from the highest annual insolvencies in Northern Ireland. So in short, the wave of insolvencies that's hit England just hasn't hit NI yet. Our bubble hasn't quite burst. And a key driver and reason for this is in England, creditors were able to issue winding up petitions from April last year, but our restrictions were only lifted in April 2023. And when lifting the restrictions, there was an entirely new winding up process introduced to Northern Ireland.
So as Chris mentioned, England are a full year ahead of Northern Ireland. They lifted the restrictions back in April last year, and as is evident from the statistics just displayed, it's been a key catalyst and contributor to the increase in insolvencies within that market. Northern Ireland then followed earlier this year, but unlike England, there are three conditions in Northern Ireland that have to be adhered to for a winding up petition to be presented. The first is that any winding up petition that is now brought before the High Court in Northern Ireland must be based on a statutory demand that's served after the 13th of March 2023. And as most of you will likely know, it's the service of a statutory demand that's often seen as the commencement of the winding up process. As for a corporate, if they're not able to make payment of that sum within the 21 days demanded, then the creditor is entitled to present a petition to the High Court on foot of their failure to adhere to that demand. And in anticipation of the restriction maybe being lifted this year, and some creditors thought, well, the Master had lifted the guidance and the restriction on bankruptcy petitions in September last year. She's more than likely to lift it in early 2023. Statutory demands were served by a number of creditors in the hope, I suppose, that they could jump the queue. But this aspect of the guidance now prevents those creditors from acting on foot of those earlier statutory demands. And pretty much any winding up petition that now goes before the Northern Ireland Court can only ever be based on a statutory demand that has been served in the period post the 13th of March 2023. So that's the first condition. The second condition is a fairly basic condition. It's that there's a new form for a winding up petition, and that has to be used post the 17th of April 2023. And that date, the 17th of April 2023, is the key date if you're wondering what date winding up petitions were once again accepted by the High Court in Northern Ireland for issuing. But it's the third condition that's the most important, and the condition that is going to have an impact on how winding up petitions operate going into the future. The third condition is that the debt, the subject of a winding up petition, now must be placed in a court judgment. This is the biggest difference with the lifting of the restrictions and winding up petitions between England and Wales and Northern Ireland, but also the biggest difference between the pre-pandemic process and now the post-pandemic process. In actual fact, it marks a seismic shift from what we were all used to when dealing with winding up petitions, and it's a real considerable departure from the previous winding up process. And in reality, the winding up process now is much more of a marathon than a sprint, with creditors, save for one key exception that I'll come back to later, now needing to go through two judicial processes to obtain a winding up order. So under the previous process, so the process that was in place prior to the pandemic, there were really only two stages or hurdles that a creditor needed to get over in order to present the petition. One, service of statutory demand, and two, presentation of the winding up petition. So if you got over the first hurdle, that is, you served the statutory demand, which was for a sum due and owing by the debtor, and they couldn't pay it within 21 days, then you were entitled to move on to the second stage and present a winding up petition against the company. And overall, the process could be around 8 to 10 weeks, a sprint in comparison to what it is now in place with the new guidance. So with the requirement now to obtain a judgment for a winding up petition, you can see the petition stage getting further and further down the track, because creditors are now presented with a much longer journey before they can even get to that petition stage, with a number of additional hurdles to get over. So if the requirement and the condition is you need a judgment, you're going to have to start with engagement and pre-action correspondence. So letter before action, response, and engagement to the debtor before the issuing of legal proceedings are going to have to take place. Once you get over that hurdle, you're going to then have to issue proceedings. So you have to obtain a judgment. And to obtain a judgment, if the debt's 30k or above, you're going to have to issue a writ. If it's below 30k, you're going to have to issue a civil bill. And then you're going to have to, on foot of the proceedings that you've issued, obtain a judgment. Now, if there's no appearance entered or no defence to the claim, then this may be capable of being obtained within a relatively short time period. But in the case where defence is mounted, whether that's a defence that will succeed at trial or not, it will have the effect of adding significant time to the process. And that is quite clear by the road or pathway within the screen. And overall, the process now could be at least 6 months from start to finish. And that's only if an appearance is entered and a defence is mounted in the most banal of ways. If there is a interlocutory applications or appeals or otherwise, it could be much longer. As reflected in the slide, it's more of a marathon now to get a petition to hearing than a sprint. So before we go on to provide some insights and hints and tips about how to deal with winding up petitions, over the course of the last few slides, we have been exploring the why and the where. That is, why the bubble's stretching and under pressure, and where in terms of sectors and industries we expect this to be most acutely felt with the return of petitions. But before we go into that practical guidance and insight, you might be wondering, but what about the when? When will it happen? You can see when it happened in England, but Northern Ireland's different with the conditions it has in place. But the question of when will it happen is probably the most difficult aspect to address. But we do feel that within Northern Ireland, we are on the crest of a wave, and that with the return of winding up petitions, there is likely to be an increase and an uptick in corporate insolvencies within the market. And to continue with the water analogy, when you remove anything that blocks a dam and holds the water back, and you allow creditor winding up petitions to return, that can only ever have an impact. But the question for us is not really about when, but really how ferocious that wave will be when it arrives. And given a number of factors, the new precondition, that is to obtain a judgment before a petition is presented, the way the market is now at the moment, and the fact that some liquidity remains within the market, we certainly do not expect the wave to be as ferocious or like the one on this slide. We expect it's more likely to be gentler. We also expect that any sort of waves of insolvencies through the return of winding up petitions will likely come in smaller waves over the course of time. The condition to have a judgment, which just wasn't there in England, also means that those waves won't break immediately. And I suppose in terms of timing then, we wouldn't really expect them to begin to come to shore until maybe 6 or 9 months down the line. And look, whilst we might not be able to predict anything with any certainty, what we can all do as accountants and lawyers is prepare ourselves and prepare our clients for the return of winding up petitions. And given that all of us will be revisiting a process for the first time in 3 years, which also has some new requirements to boot, it's important that we're ready to react. And that's what we have termed making preparations for winding up petitions 2.0 and the guide for providing our insights into them.
And the worst thing that a company and its directors can do when coming under creditor pressure is to bury their head in the sand and hope that the problem will go away. Time and time again, we've seen valuable companies that could be saved ultimately become doomed due to a failure of the company and the directors to react. So react is the phrase that we've used to summarize all of the key points that companies and the directors need to be thinking about when they're coming under creditor pressure, with each letter standing for a different key point, the first of which is receipt of demand. Now, you'll have noticed that we've deliberately chosen to include a group of individuals on this slide. And that's because, as Sam explained, the journey to a winding up petition now begins with a demand letter and litigation. And the companies and the directors will struggle to deal with this process if they don't have an experienced team of advisors around them, consisting of both lawyers and accountants working together in order to prioritize the company's needs and prevent its bubble from bursting. So if a demand from a creditor is received, the first thing you need to be asking is whether or not that debt's disputed. Many of the arguments you might raise are obvious. For example, the creditor might be overcharging, they might be seeking payment too early, or they might also have been defects with the goods and services provided by the creditor, so the full amount isn't due. But some of the arguments that you can raise are more legal. For example, a limitation argument. The creditor might have committed a repudiatory breach of contract prior to the demand. The creditor might not have served the demand appropriately in line with the contractual terms. Or there could even be unfair contractual terms, or if the creditor is a regulated entity, the creditor might be pursuing inappropriate means of debt recovery. And if we moved beyond a simple demand letter to a statutory demand, well, if your client is a sole trader, then they can apply to set that statutory demand aside. But if your client's a company, then that statutory demand cannot be set aside, and the company will need to apply to court for an injunction restraining the presentation of a winding up petition. But importantly, the new guidance has introduced an additional requirement to think about when it comes to statutory demands, because if it is not based on a judgment debt, then it cannot be used to ground any winding up petition. This might catch out some creditors, but the wiser creditors will be aware of the new process and immediately issue writ or pre-action correspondence. And if a client has come to you saying that they've received a writ, the first thing you should be checking with them is whether or not they filed an appearance within 14 days of service. And the reason why this is so important is if a company fails to enter a memorandum of appearance at court, well then the creditor can apply to mark judgment in default. And this effectively creates a race between the company on the one hand to apply to court and set that default judgment aside, or on the other hand, the creditor, who will be seeking to quickly issue the statutory demand based on the judgment and a winding up petition thereafter. So if your client is telling you that they've received a writ or a default judgment, but they haven't really engaged in the legal process, that's something that needs to be addressed as a matter of urgency. And if there is a considerable amount of creditor pressure or there are multiple demands against the company, the directors will also need to receive advice as to whether or not they've complied with their statutory and fiduciary duties as directors, and whether it's legally appropriate for them to continue trading. As Sam and I mentioned in our presentation to the Society a few weeks ago on the charity sector and funding cuts, directors owe duty of care to creditors whenever insolvency is likely. And a breach of this duty can give rise to personal liability. So it's important that the directors receive advice at an early stage as to what their potential liability might be. And having gathered together this team of advisors, it's important for the company to then begin engaging with the process. And you'll notice that we're back on that road we looked at earlier, the end point of which is compulsory liquidation and a winding up order. That tends to be the worst outcome for the company, both the directors involved and the individual creditors affected by it. But if appropriate legal and accounting advice is received throughout the process, then there are many signs and alternative options along the way that could lead to a more positive outcome and a turnaround for the company. In the simplest of cases, settlement agreements might be used in order to achieve this, where a creditor will accept payment of a lower amount, or perhaps accept payment over a longer period of time in order to settle the debt. And commercially, it's in the creditor's interest to enter into a settlement agreement because they will then avoid the cost, expense, and time incurred in dealing with any litigation. And on the topic of commerciality, this is where it's important that the company has that team of advisors around them who can provide trusted, strategic, and practically sound commercial advice to help navigate through the current creditor pressure facing the company. Settlement agreements are particularly useful where there's only one or maybe two creditors. But if there are multiple creditors, then the company might be better pursuing a company voluntary arrangement. This is technically an insolvency process, but it can lead to recovery for the company, as this arrangement results in a pence in the pound settlement of all unsecured creditors and the remainder of the company's unsecured debts being wiped clean. Now, you might be wondering why any creditor would accept this, and it's because CVAs still typically produce a greater return to creditors than a compulsory liquidation would. And the beauty of a CVA from the company's perspective is that if the requisite majority of creditors support the proposal, then the CVA arrangement will bind all creditors, even those who dissented and voted against the CVA being introduced. Another insolvency process that might result in saving the company is an administration. And this can provide statutory protection and a bubble to the company via the statutory moratorium, which prevents and prohibits creditor action and debt recovery proceedings against the company. An insolvency practitioner will be appointed over the affairs of the company, and they might seek to realise it as a going concern and save jobs where they can. And if the directors and your clients are interested in pursuing administration, then they need to act quickly. due to the fact that if a creditor beats them to it and issues a winding up petition, then it will no longer be possible for the directors to appoint an administrator to the company. So it really highlights the importance of acting early. And if none of these options are available, then it's very likely that the company will enter into some form of liquidation process. But this doesn't have to be a compulsory liquidation. It's still in the company's interest to consider whether a creditor's voluntary liquidation is appropriate. Yes, it is still a terminal event for the company, but it can result in a more cost-effective and orderly wind down of the company's affairs. And it would also be strong evidence that the directors were taking their duties to creditors seriously in the run-up to the company's insolvency. But if none of these options are pursued, then it's very likely that the company is going to receive a winding up petition and potentially a compulsory winding up order thereafter. And that's a real game changer for the company due to the impact it has on the company's bank account. Because the bank will typically block an account as soon as a winding up petition has been issued. And this obviously has a considerable impact on the company's ability to trade, as they're no longer able to pay the employees or any core suppliers. And to understand why the banks block bank accounts, it's important to kind of make a distinction between two periods of time, the first of which is that period before the petition. Because transactions in this period might be challengeable as a transaction at an undervalue or a preference, which is a risk that the directors of the company need to be aware of. But the bank doesn't need to be concerned by this, because transactions during this window are voidable. In other words, they're presumptively valid until they're set aside, and they're not void. But as soon as a winding up petition issues, for any transactions between the winding up petition and the order being made, those transactions are void. And there's consequently a risk of liability for the bank, who might need to account to creditors for all transactions that occurred during this window. And that's why the bank will block the company's account. Now, there are some arguments that the company might be able to raise to prevent the account being blocked. The first of which is they could try to argue that the bank is acting in breach of contract of the contractual terms and conditions that govern the account. But this argument, it's not really likely to get off the ground, given that the bank will have drafted the terms and conditions and will have deliberately included a reference in virtually all cases that the accounts can be blocked if a winding up petition has been issued. Secondly, you could try a bit more technical legal argument and argue that the bank has no justification for blocking the account following the decision of Bank of Ireland and Hawley Court. In this decision, the Court of Appeal effectively held that banks are simply acting as agents of the company. They're part of the payment process, and they're not controlling or benefiting from these transactions. And therefore, the bank shouldn't be held liable to creditors for them. But as with all court judgments, there is a bit of a grey area and a bit of ambiguity, and there's still a degree of risk for the bank, which means the bank will be very reluctant to unblock the account, particularly because there is a third option for the company, which is seeking a validation order. And that validation order would be an application to the court, whereby the court will then approve of certain transactions and allow these transactions to go ahead, even though a winding up petition has been issued against the company.
Once a wind-up petition is presented, the bank is not the only creditor that will begin to increase pressure on the corporate, nor should you or your client's reaction to the receipt of a winding up petition be to solely focus on the creditor who's presented it in the first place. I accept that it is, of course, easy within the winding up process to focus on the one creditor who's banging at the door, so to speak, but that can be really dangerous, as there are other groups of creditors who you need to keep a close eye on within the winding up process. Let's take three groups or bubbles of creditors in turn. Firstly, trade or other unsecured creditors. It's important to note that just because you reach a deal for yourself or for your client in respect of the presentation of a petition, and you document that by way of a settlement with the creditor who presented the petition, that it will result in the dismissal of the petition and the end of the process. Once the winding up process is commenced and started, it cannot be stopped unless the master approves that. That is, the dismissal of a winding up petition is something which is at discretion of the master. And one thing that it is particularly important, therefore, to keep an eye on is other creditors who are circling, particularly creditors who might be termed supporting creditors. I'll give you an example of that. If one petitioning creditor, for example, withdrew a petition as against one of your clients because they've been paid off, and another creditor was capable of presenting a winding up petition, they can substitute in and step into the shoes of that other creditor. So it is extremely important not to get caught up in the weeds with the creditor who's issued a winding up petition, and to keep an eye out for any other creditors who may be waiting in the wings to swoop in. A second grouping of creditors to be aware of and to keep an eye on are landlords. Landlords were heavily restricted throughout the pandemic. They couldn't exercise rights of forfeiture, they couldn't make use of statutory demands to seek rent arrears, and they couldn't present winding up petitions. That, of course, has now changed. And there are two things in particular to note in respect to the position of landlords. The first is that some of them used their time very wisely during the latter period of the pandemic. And using that time wisely, they've already obtained judgments for rent arrears on their leases. Those landlords, therefore, are already ahead of the game and ahead of the queue in terms of other creditors when it comes to issuing of the winding up petitions. If you think back to the track, they've already knocked over the first three hurdles and can immediately go to the statutory demand. Secondly, landlords also have another remedy, and that is the remedy of forfeiture. And they can exercise that right of forfeiture on leased premises where there are arrears of rent. And provided that this is done peaceably, this can allow them to regain control of a property without the need to resort to litigation, which of course can also have disastrous consequences for the future trading of a company. And it's therefore vitally important that you keep an eye on what the landlord is doing. The third category of creditor I want to mention is the company's bank or primary lender. They are one of the most, if not the most important category of creditor to engage with when a winding up petition is presented against a corporate. This isn't just because of the blocking of an account issue that Chris has just mentioned, but primarily because in almost all cases, the bank will hold the best hand when it comes to determining the outcome for the company. In many cases, the bank will hold security, and with that, that brings a number of rights. Those rights include some of what are set out in the slide. Firstly, the ability to set off credit balances as against debit balances. And if you were looking at turnaround or a CVA or some form of mechanism to navigate the company out of the predicament it's in, the ability of the bank to move in and set off can have a significant impact on ongoing or future trading, or the ability to turn around the company if those funds are no longer available. And secondly, if the bank has security, then the bank will have the ability to take the decision of where the company goes on the path to recovery outside of the company's control. For example, they could enforce their security, which could involve the appointment of a receiver of an important property asset, or they could appoint an administrator to the business and affairs of the company and in effect take the decision completely out of the director's hands. Finally, the last aspect of REACT is the company's tax position. And within the new winding up process, the company's tax position is of considerable importance. When it comes to HMRC and the new winding up process, there are really three key differences, which are also three significant advantages for them as a creditor of a corporate entity. Displayed here is three crown jewels. Firstly, I mentioned earlier that there was an exception to the rule, and there's an exception within the guidance that the Master has issued that HMRC is the only creditor that does not require a judgment before they can issue a winding up petition. Therefore, at present, HMRC are pretty much unrestricted when it comes to the issuing of winding up petitions. It remains a sprint for them, what we have termed a fast-track petition. Secondly, HMRC, unlike other creditors, other ordinary unsecured creditors, have a right of distraint, and they can exercise that right of distraint provided that certain conditions are satisfied against the company's assets. So if the company is reliant on those assets for future trading or to enable it to do a CVA, the exercise of such a remedy by HMRC can have significant consequences, given that those assets will in effect be uplifted by them and sold off in payment or part payment of the debt due to the revenue. Finally, HMRC's position as a creditor in a company's insolvency is now significantly enhanced from that which it used to be pre-pandemic and that which it was when we last experienced winding up petitions. And the reason for this is that in late 2020, there was a reintroduction of what is termed secondary preferential status for HMRC. The slide that's on the screen now reflects what the position was pre-December 2020. That is, when we last had to deal with winding up petitions, HMRC were at the bottom of the rung of the ladder. As an unsecured creditor, like any other trade creditor of corporate, they would only have been paid out after fixed and floating charge security, and in most cases, outside perhaps of a small prescribed part dividend, they would have received little to nothing within many corporate insolvencies. This now, however, has changed with the introduction of what is secondary preferential debt for HMRC. And as you can see in this slide, this has had the effect of moving them up the payment waterfall, where they are now paid in advance of a bank's floating charge. And whilst fixed charge holders, of course, will continue to be paid out, this for HMRC marks a material change to their treatment on insolvency, and also potentially acts as an incentive for HMRC to present winding up petitions in certain cases. And whilst this was, of course, introduced back in 2020, it isn't something that's new. The reason I raise it is we haven't yet seen this impact in the local market, given the low level of insolvencies there's been. But this is something to keep a very close eye on. So to close off on React, as you can see, HMRC have a very privileged status. And within the new winding up process, close attention will need to be paid to them and also to your clients or companies' tax affairs. So that's the hints and tips in terms of React and how to prepare for winding up petitions and the return of them. But before we close off this afternoon's webinar, we thought it might be useful to remind you all of the extent of the publicly available information there's available to you when you're engaging with your clients. It might, for example, be the case that you want to check out a proposed counterparty or proposed director in a counterparty that one of your clients is going to contract with, or you may have heard a rumor within the market that affects your firm or your clients, and you want to check it out. So each of these links in the slide is a QR code. So if you use your phone, you'll be able to quickly go from the screen to each of these publicly available sources of information to check many things, whether a director of a company's in the IVA register, whether a petition's been advertised in the Gazette, to check what judgments are recorded within the Gazette, which is becoming increasingly important given the precondition for petitions. You can also click into the daily court list to have a look at what court proceedings are going on or who's before the winding up court. Or ultimately, you could check whether or not a director has been disqualified or not. These slides will, of course, be made available to members after this webinar. So hopefully this QR code slide can act as a useful quick link or reminder to you of the sources of publicly available information that there is. To close off this afternoon's webinar, look, React is pretty much all about ensuring you or your clients don't freeze, that they aren't paralysed when a winding up petition arrives, but most importantly, that they act from the receipt of the demand stage to ensure that a winding up petition never actually arises or materialises for them. And at the core of this is really ensuring that within any corporate, there's proper governance, responsibility, strategy. And with proper legal and accountancy advice, companies faced with any issue, whether it's an issue, a funding issue, a finance issue, a petition issue, that they can minimize those risks in such a crisis and equally maximize the opportunities that there might be. That allows the bubble, as you can see in the screen, to grow sustainably, not to stretch or feel pressure. And through proper advice and effective stakeholder management, the bubble can hopefully navigate itself past any of these challenges or darts the market throws at it. But that pretty much concludes what Chris and I want to say today for the webinar. We've tried to keep it, thankfully, to about 45 minutes. I hope you all find it interesting and informative. And we do have a short window, of course, for some questions, and we're happy to take a couple of questions if there are any.
Okay, thanks very much, Sam and Chris. That's been a great summary of a lot of change in the last few years. So there are a few questions. I'll start with an easy one. Have we returned to in-court, in-person court hearings?
So, Gillian, the answer to that is a bit like the rest of the world, a mix between yes and no. So in terms of the court proceedings that you need in order to obtain that judgment debt, they all have returned to in-person. And there's been recent guidance issued by the judiciary on this, whereby the starting point is all parties are to attend in person in court at all times. And if you do want to attend via site link, you need to ask for special permission. So all of those site links that you've been used to using during the pandemic, they're no longer going to work, and you're not going to be granted access unless the court has given you permission to attend in advance. But when it comes to the winding up process, they are still going to be heard remotely via WebEx. So if you do have an interest in any winding up petition that's pending before the court, you will need to write into the court in advance in order to obtain that WebEx link. So much like all of us, it's a semi-hybrid approach at present.
Okay, thanks, Chris. A couple in relation to the HMRC positions. So the first one, what debts are HMRC secondary preferential creditors for?
Yeah, I'll take that one, Gillian. I think that a lot of them, pretty much. So the debts that now fall into that bracket of secondary preferential status, so get them paid out ahead of a bank's floating charge, would include VAT, PAYE, national insurance contributions, student loan repayments, and construction industry scheme deductions. So not every element of tax is due to HMRC, but I think that the best way to phrase that would be a significant proportion of them.
Okay. And related to that, then another question here. Since a writ is now required to obtain a court judgment prior to being able to issue the winding up petition, does a solicitor need to be instructed to issue the writ, or can an accountant issue the writ?
If the debt is due and owing to the accountant's firm, they could issue the writ in their own behalf and could seek to obtain judgment that way. But if it's on behalf of a client or of the firm, they would need to engage with a lawyer to issue the writ. Okay,
thank you. I've one here from Rachel Fowler. So she said, Sam, great presentation, very informative. Given the length of the process pre-winding up, do you think we will see more director duty transaction challenges as this runs through?
Yeah, that's a good question. I think that the landscape's likely to change, because if it's going to be such a long period of time before you get from even to the petition stage into the order, then IPs, when they go in as administrators and liquidators, may not be able to have in their armory going after preferences or transactions at undervalue, because the time periods may have expired by that stage. So I agree with what Rachel's saying, that I think that we're going to have to look, both as accountants and lawyers, at more innovative and creative ways of asset recovery into companies whereby those assets shouldn't have left the companies. And that may mean looking at breach of director duties. Have they breached their fiduciary duties? Have they, is any assets held in trust? When we've already began to see that within some of the actions that are moving before the courts in Northern Ireland, where there are local IPs that are having to become a bit more innovative and creative in the way in which they're going about that, because the ordinary actions that they had to recover assets for the state just aren't available to them.
Okay, thanks, Sam. One from John Dickinson. Due to the extended collection period now, what would be reasonable collection costs under the late payments legislation?
The extended collection period, the extended collection period, I need to understand the question a bit more around the late payments legislation. But if you're going for issuing a statutory demand or serving statutory demand as against the company, you'd be entitled to recover the interest on that and interest for late payment of debt. If you were to go before the High Court by way of the writ, you could seek interest on that at the court rate of 8%. I don't know exactly what John's referring to in terms of reasonable collection costs, but typically the cost that you could recover within a writ action would be the legal costs as against the entity that you've issued against, and those costs can then follow through to statutory demand and petition stage.
Okay, John, maybe if that doesn't answer your question, you can drop an email in and we can follow that up. So just a couple more before we wrap up. If anybody else has any to add in, now's your chance. On what basis would the court grant a validation order to bank?
One of the bases, Gillian, that a court would grant that is if the company can show that it's solvent and it can pay its debts. So that's unlikely to be the case if we're at the stage where a creditor has obtained a judgment and we're now in compulsory winding up proceedings. But another circumstance where a court might grant a validation order is where the company can show that it's beneficial to, or at least not prejudicial to, the class of unsecured creditors. And that is likely to be the case in respect of employee wages, due to the fact that employee wages typically rank as preferential debts, so they're paid in priority to unsecured creditors in any winding up anyway. So that would be the requirements that you would need to prove to the court before you got your validation order.
Okay, so that would really be for each sort of class of transaction, or maybe even individual transactions, Chris?
Yeah, you can't really get a wholesale validation order. They're transaction specific. So it might be the case that you bring one application and there's 4 specified transactions, for example,
Gotcha.
but you're not going to get a wholesale order for any transaction during that window.
Okay. Sam, John has just come back here into the Q&A, and he says you can charge reasonable collection costs, but these will now increase.
Yeah, given the period of time, is maybe the point he's making. Yeah.
Okay. Okay, folks. I think that wraps it up. Thanks very much. Oh, sorry, one more, Brian Haggerty, just in there quickly. Is there any sign of LPS increasing its activity to obtain judgments and issue winding up petitions?
There is signs, I think, that there has been increased activity, both LPS, HMRC, in terms of getting demands out, and those sort of demands for them in terms of a demand letter and a statutory demand is the precursor to then the petitions. I think from looking at the court lists, there is evidence that sort of change, as I mentioned, around support to self-interest is beginning to creep in there, but it's going to take a long period of time, I think, to flow through in terms of how we see it within the court lists. There's only maybe 5 or 6 or 7 being listed on a Thursday of each week. We now are two or 3 weeks away from the end of the court term, so I think it'll be a lot better position to answer that question and what it looks like when we see what the status of petitions is when they return in September and the courts return in September.
Okay, thanks, Sam. Okay, folks, just to wrap up then, thanks again to Sam and Chris. Really good session. There will be a link sent out, I believe, tomorrow to all registered participants, which will contain a link to the recording of the presentation. So if you want to look back on any of the detail, or indeed the QR codes, which could provide some interesting reading and insight, that should come out tomorrow. We're hoping there'll be a future series of the webinars with ANL Goodbody starting in the new term in September. So just keep an eye out on the Ulster Society communications that come out, and see what topics are coming up after the summer break. So Sam, thank you. Chris, thank you. Enjoy your summer. Thanks to everybody for attending. I hope you find that useful. Thanks, everybody.